Hello, this is Michael Lowe. So you're shopping for a criminal defense lawyer. What are some tips that I can give you to help you communicate better with a lawyer and find the best lawyer for you? The first thing that I want to talk to you about is the way that I do things in my law practice and the way I operate. And then I also want to give you some tips on some things to watch out for when you call other attorneys. When you call my office, the first person that you're going to hear from is a person who answers the phone, a secretary, and she's going to take down all your information. She's going to ask you a lot of questions about who are you calling for? Are you calling for yourself? Are you calling for a loved one? She's going to ask you questions about whether you're calling for a state case or a federal case, if it's an investigation, who's involved, which police agency, where is it. You'll get a lot of questions, and do your best to give that information to the secretary, because I will receive that information. And a lot of times before I call you back, I will do independent research to gather additional information before I call you back. And I will call you back if it's a new case and it's something that I can help you with. I will call you back. And when I call you back, I probably will have a lot more information about the case than maybe even you have. And that's because I make a habit of looking into cases before I call people. I will look on the internet. If it's a federal case, I will go onto the PACER system. If the case is not under seal, I will get the indictment. I'll check the court dates. I'll find out where the case is filed and look at any new updates in the case that are on the computer. If the case is under seal, it's a federal case, and I'm not going to be able to do that, but there are other things that I can do later on, maybe check with the court to get an update or check with the United States Attorney's Office. If it's a state case, most counties in the state of Texas have computer systems where I can check the computer to see what the status of the case is. Now, when I do all these things, I'm not going to be able to get police reports. I'm not going to be able to get videos. I'm not going to be able to get the evidence in the case, witness statements, but I will be able to get some relevant information that can help you evaluate things and also help me evaluate things. The other thing to know is that if you're calling for a loved one who's in jail, I will talk to you, but for most cases, I do need to go speak to your loved one in the jail before I can quote a fee and before I can really give you any good feedback about the case. The reason for that is because I'm going to ask you a lot of questions and you're not going to know the answers because you're not the person in that situation. So I will answer your questions the best I can, but I will probably at some point tell you, hey, I'd really like to go see your loved one in jail. At that point, I will charge a fee to do that. Depending on which jail it's in, the fee can range anywhere from $250 to up to maybe $500 if it's a far away jail. But that's usually the method that I use. Usually the first question somebody asks me when they call me and I talk to them for the first time, they'll ask me, how much does it cost to hire you? And before I can answer that question, I need to gather more information, because the way I charge fees, I charge flat fees for my cases. And a flat fee basically means a fixed fee that I put in writing and I give to the client, and everybody knows what the fee is going to be beforehand, and the fee never changes. If the case ends up being more difficult than I thought it would be, the fee remains the same. If the case is easier than the client thought it would be and I get it dismissed very fast, well, the fee remains the same. Typically, flat fees work out better for clients. I know other lawyers, and I've actually many years ago used to practice civil law. And I've seen how billable hours can take over a lawyer's practice. That's not how most criminal defense lawyers practice, and in particular, I only charge flat fees. Now, there are times on federal investigations where I have to charge by the hour, but that's the exception. That's really not the normal scenario. So in most cases, folks will call me and they'll say, hey, how much is it going to cost? And I can't really answer that question. I will usually quote a flat fee at the end of the phone call, though. So by the end of the phone call, I can usually quote a flat fee. Now, sometimes cases are so complex, or if you're calling for a loved one and they're in jail, I can't quote a flat fee at that point. I have to go visit your loved one in jail. I have to gather more information. Or if the case is that complicated, maybe an office consultation is really the better plan before I can quote a flat fee. It is rare, though, that I will require an office consultation before I can quote a flat fee. And the reason why I say that is because most cases that people call me about, I've done before many, many, many times. I've had many trials for that type of case. I've had many other court appearances and hearings and motions, and studied that area of law very carefully. So I know what to expect. I know what to expect from the judge and the prosecutor. So I know approximately how long it's going to take me to resolve the case. And so I usually know how much of a fee to quote. But sometimes it's important instead to meet with a lawyer. And at that time, I will invite you to my office, and I will give you the reason why I think it's a good idea for us to meet. And at that point, we'll have an office consultation. And the office consultation is a little bit different because I will charge a fee for that. Typically, I charge around $250 or $300 for an office consultation for an hour. The advantage of doing an office consultation with myself is that you're going to get a lot of feedback in the office consultation situation. Typically, folks will bring friends, family members with them. They'll bring documents. They may bring pictures and videos. You can bring as much evidence as you want to bring. And we can talk about whatever you want to talk about in that hour. And I'll look at all the documents you have. I'll look at all the videos, all the pictures. I'll talk to your family members. And in those scenarios, it can be a very productive meeting, that 1 hour. So that first hour can be a really good opportunity to ask me a lot of questions and also get a lot of feedback from me about what I think. Now, of course, we can't make any final plans during that first meeting, but I can give you some really awesome feedback about your case. And sometimes I can tell you things about your case that you don't really know or understand, and really turn things around for you. Many, many times folks come in, and after they're done talking to me in the office consultation, I can just see a weight lifted off of their shoulders. They can feel so much better about their situation. A lot of times folks overestimate the trouble that they're in, and by the time they talk to me, they realize that they're really not in that much trouble. And that leads me to the second part of the office consultation that I want to get into. Sometimes the office consultation ends there. So sometimes that's the last time we'll ever see each other. You come in for an hour, you'll ask me questions, I'll tell you what I think, and that's it. And the reason why that is because a lot of times folks will call me and think that they're in big trouble. And it can be hard for me to discern how much trouble that person is in just talking over the phone, and it's better for us to speak in person. And if we speak in person and we have an in-depth discussion about the problem, and I get enough information, sometimes I can tell that person that they're not in trouble, that there is no criminal case. Okay, so now we've talked about my office policies on communication, how I operate when I communicate with clients for the first time or when I communicate with loved ones for the first time. We've talked about jail visits. We've talked about quoting fees on the phone. We've talked about office consultations. So we've covered most of the stuff that I do. Now here at the end, I want to talk a little bit about when you call other lawyers. Some of the things that I've heard. I've been doing this for 21 years, so I've heard a lot of things about what other lawyers do and other complaints that people have about the way other lawyers operate. And so in this part of the video, I'm not trying to badmouth another lawyer or anybody in particular, but what I want to do is kind of show you some things that I've seen in the past that other lawyers may do that I think personally I would never do. And so there's sort of like red flags to watch out for when you talk to other attorneys. So the first thing that I would say is that when you call a lawyer's office, if you do not hear back from the lawyer, but you hear back from, after you've left the first message, you hear back from a secretary or from a legal assistant, or maybe from a younger lawyer who's not really the lawyer that you called for. If you hear back from those types of people, to me, that's a red flag, because in criminal law, unlike other areas of law, when somebody calls for a lawyer, they want that lawyer to represent them. Criminal law is different from other types of law. It's different from family law. It's different from civil litigation. And the reason why it's different is because it's the state of Texas versus the name of my client, or it's the United States of America versus the name of my client. Criminal lawyers, we are not representing corporations or large entities. We are representing individuals, and we're not just representing individuals, we're representing folks charged by the government in the most serious crimes. And so I take that very personal. I know my clients take it very personal, and so the relationship should be established between the client and the lawyer and nobody else. So the way I operate is when I get the message, I gather the information, and I personally call the client back and establish some sort of relationship. Now, that's not to say that that's going to go perfectly. Sometimes people listen to what I have to say. Sometimes they don't like what I have to say, and that's the end of the conversation. In those situations, it doesn't hurt my feelings. I understand that not everybody's perfect for each other, so there's lots of options, and you could find somebody else for sure. But it is a red flag if you call for a lawyer and you don't hear back from that lawyer, or you hear back from a secretary or a legal assistant or another lawyer. So that's something I would watch out for. Another thing I would watch out for is if you hear back from a lawyer that you're looking for and you ask that lawyer how much does something cost, and they answer your question right away, I think that's a red flag. And the reason why I say that is because that lawyer really shouldn't know how much to charge in a case if they're charging flat fees, if they don't know anything about the case. And they're really not going to know anything about the case if they just got you on the phone. So they haven't asked you a single question about, the facts of the case, what happened, that sort of thing. Every case is different. That's the way I treat my cases. So every single case I have is unique, it's special. Every client is unique and special. It doesn't matter if it's a Class C misdemeanor assault case in a municipal court, or it's a major multi-defendant federal conspiracy case in the Eastern District. All cases are the same to the client. They're all equally important. So I treat each case as an individual case. So if you call a lawyer and the lawyer can quote a fee right away, it might be a sign that that lawyer doesn't see you as an individual, but just sees you as a case. And that is a red flag in my opinion, because that lawyer needs more information. Now, the other red flag that I see often is that sometimes folks will tell a lawyer certain factual scenarios or present a problem to a lawyer, and the lawyer will quote a fee, but they don't really have a plan as to what they're going to do. I will usually tell people what my plan's going to be over the phone. Now, sometimes that plan will be sort of vague in general because I don't have all the information. Sometimes I have very specific plans and very detailed instructions about what I think I want to do with the case. For example, like in an investigation type case for a state case, I'm going to tell you right away, we're not talking to the police. And I will also tell you what else I can do to further the investigation in our favor. But there are very specific things that I will tell you. But what I've seen in the past is clients will call other lawyers, and the lawyer will quote a fee, but then they don't have any plans or specific recommendations that they're making over the phone, or they may go to the lawyer's office for an office consultation and they walk out more scared than they were before they walked in. That's not a good sign. So the lawyers should have a plan. They should wait to hear about the case and gather as much information as possible before they quote a fee, and they should look at you as an individual, not as a case. So now let's talk about the plan of action. A lot of times folks, when they call me, or when I hear about folks who have called me and they've called other lawyers, they tell me that they will ask the other lawyer or ask me, what are you going to do on my case? And I will give some feedback to that person after I've gathered enough information. Based on that information, I can usually give some feedback about what my plan of action will be in that case. And the reason why I do that is because I want the client to know that I will have a plan. Now, that plan can change. If the facts of the case change, the plan may change. But the point of telling the client what the plan is initially is just to let them know that there will be a plan, and that plan is going to be constructive and usually will get results that are favorable to the client. A red flag to watch out for, though, when you call another lawyer is sometimes that lawyer will quote a fee, but they will never present a plan of action, a specific thing that they're going to do in the case. And this can be a really big problem sometimes, where you may be calling about an appeal or a writ of habeas corpus, or you may be calling about an expunction or a non-disclosure because you want to get your record cleared, or you may be calling to, if you're a registered sex offender, you want to deregister as a sex offender. Well, those are all very technical legal areas, things that I do, but those are areas where there are very clear legal black and white guidelines that apply, where either you can do something as a lawyer to help a client, or you cannot do something to help a lawyer as a client. That could be because a statute of limitations has expired, a deadline has expired to file an appeal, a deadline has expired under AEDPA to file a 2255 or a 2254 in federal court. Maybe they're not eligible to deregister. Maybe they're not eligible to have their record expunged. Maybe they're not eligible to have their record sealed. Maybe they're not eligible yet, but they will be in the future. Those types of things. So if you call another lawyer and that lawyer quotes a fee right away in a case like that, an appeal, a writ, a case like along those lines, that's a big red flag, because that lawyer needs to know whether or not they can even help you to begin with. And unfortunately, there are times when people pay lawyers to do things that are legally impossible to do. So it's important that you hear what the plan's going to be from the lawyer about how that lawyer can specifically help you if you pay them a fee. And that is something that I can do in your case.